Hello, you've got Ted Corless with the Corless Law Group, sitting here today with an engineer, Byron Anderson, who you should know by now, as well as Dan Greenberg, very experienced condominium attorney. The three of us are sitting here today chatting with you about a very important event that took place recently following a special session of the Florida Legislature. There is a podcast that we published previously about this particular issue, and we were on this topic as a result of the Surfside collapse that took place in southern Florida, ending the lives of nearly 100 people. Following that particular event, there was a lot of legislative conversation and activity in both the House and the Senate during the regular session on what could be done to increase the safety of people who live in these particular environments. It turned out at the time of the legislative session that the hang-up between the Senate and the House was whether or not the new law would obligate boards of directors for condominium associations to always fund their reserves. Again, let me lighten that up a little bit. If you live in a condominium, your board of directors is responsible to cover the costs associated with the daily maintenance of the structure. In addition to that, under most condominium association rules, the association was also supposed to pre-fund things that have long lifespans, things like roofs, things like windows, and pavements. But most of the time, you would have a significant number of the associations that would meet in January of every year, and they would tell themselves that they were going to waive reserves. That means that they aren't going to pre-fund these items, but they're going to wait until the very end, until the roof, for example, reaches its lifespan. Once it ends its lifespan, then they would assess the individual unit owners. Now, the passing of the new milestone inspection, which we're going to talk about with Byron, the kinds of inspections that are now going to be called, they have instigated a new rule that says that you must actually fund these reserves under certain circumstances. This is going to be something that will have a material impact on the regular management of the finances of any condominium in the state of Florida. And if you're on a board or if you're a unit owner, this is a subject you're going to need to explore and get a minimum understanding of. Let me begin by asking Dan Greenberg, who is the person I go to when I have questions about condominium law. And let's talk about this new law. Dan, why don't you introduce us to this new law that Governor DeSantis signed during the special session?
Sure. Thanks for having me back, Ted, and hi, Byron. Okay, well, this was a doozy and frankly caught most of us, I think, by surprise after the initial bills had failed in committee and didn't make it through in the regular session. And seemingly out of the blue, we were hit at the end of May with this new law that imposed, as far as what I've seen in the last 12 years of doing this, some of the most significant changes to the condo laws and related laws that I can recall. And what essentially we're sitting with now is a law that has created the requirement for condos of 3 stories or more, which is the first important threshold matter to understand. Most of this will not relate to condos that are less than 3 stories. But for those condos in the state that are 3 stories or more, they now have to complete 2 unique types of inspections and reports that will be published to the state, to their members, and will be used to calculate reserve funding for the remainder of the life of the condominium. So essentially what the law creates is first an obligation to do what is called a structural integrity reserve study. And a reason I start here rather than the milestone inspections is because we have 2 timing elements that we really need to come to grips with. The structural integrity reserve study is going to have to be completed by all condos with any buildings of 3 stories or more. And this means that within some condominiums, you may have some buildings that are 3 stories or more and some that are less than 3 stories. For those buildings that are 3 stories or more, they will have to complete a special reserve study by the end of 2024, December 31st, 2024. Many condos have completed reserve studies in the past, and so if you're not aware, the reserve study is something that's been around for a long time. It was an optional study, though. Alternative to that, you could have tried to use contractors, specific contractors, to determine the useful life of your component, whether it's the roof, the painting, the asphalt, and elevators, anything with an expected useful life and a cost over $10,000 to replace. These professional groups would help the board create their budget and their reserve calculations and refresh those studies every few years. And this is something that has been a valuable tool to condos for many years.
All right, let me stop you for a second because I want to kind of back up so I can make sure that for purposes of simplicity. So before this law passed, if I lived in a condominium in the state of Florida, the condominium was required's a flexible word here, but they would have been required to fund a reserve of money that would be collected today. And where would that money go in a reserve? Would it be put in a special account to be tracked in the event it's needed for the future? Is that how that works?
Yes, they're put in specific accounts that have to be identified in the association's finances. They cannot be commingled with the operating account. And in fact, each individual reserve account needed to be separate unless you took an action called pooling, which required a board action and a membership vote to transfer funds. But these would be specifically enumerated accounts that show up on the association's financial reports that are tracked separately on the budget so that each item that falls under the statutory requirements could be specifically identified and tracked.
Okay, but up to this point, up until the passing of this new law, if I were on the board of directors of an association, I could file a motion with the board to waive reserves, or does it require a vote? Would it have required a vote of the members of the association to waive?
Yes. The way that works is the board during budget season really has two options. They can choose, without any input from the members, to pass what's called a fully funded budget. And I think we covered this in the first pod, but just the very brief overview for anyone who hasn't heard that yet. Full funded means we're collecting enough each year so that at the end of the useful life of that component, we have enough in the account to pay the full bill. So we've got our $1 million roof. It's got 10 years left. We collect $100,000 a year. At the end of 10 years, we have $1 million. That means we are fully funded. So if I'm in year 2 of that and I have $200,000 in the roof reserve account, I'm considered fully funded. I do not have to have $1 million in the roof reserve account to be considered fully funded. So the board in any given year could pass a fully funded budget where they calculate all of these expected useful life and replacement cost values. They plug it into the spreadsheet. They come up with a number. They submit that at the budget meeting to the membership, not as a question, but rather as a mandate. And the owners then have to pay the assessment level based on the calculations in that budget. There was an option, though, all along, so for all of these years, many, many years, for the board to ask a question of the membership. So this goes beyond the board's purview. If the board does not want to fully fund the budget, because we want to keep the assessments down, they would pose the question during budget season to the membership. They would take a vote by a majority of a quorum standard, and if they achieved that vote, they could then adopt a partially funded budget that either had lesser reserves than necessary or theoretically even no reserves at all, $0, and that was perfectly legal.
All right, so now what we have is a situation where if, I'm representing an association right now that is a series of duplexes, and they're all one story. So in the context of this new law, life doesn't change for that association. Is that what you're telling me?
So without getting too far in the weeds, because we have more important things to talk about, with Byron.
Sure.
But the short answer to that question is that unfortunately, and this is part of the problem with the bill, and there will be corrective legislation, I'm sure, in subsequent years. However, as it stands right now, the language of the current bill indicates that after 2024, so starting with the budget year of 2025, even those one-story and two-story condos and duplexes will not be able to waive funding in their reserves for the items that are identified in the Structural Integrity Reserve Study, which we'll get to in a second. So this is causing great panic, Ted. This is one of the questions I'm getting regularly, and we can touch on that later if we get there. But I think that will get fixed, by the way. But right now, it will impact the two-story and lower condos. Okay,
very good. Very helpful. Okay, because I think it's important for us to understand the before and after. And I think you helped us with that tons. So let's go ahead and talk about, let's move back through the reserve study.
Okay, so now this new Structural Integrity Reserve Study, or if you want to call it SIRS or whatever you want to call it, that's fine. So the new reserve study requirement for the 3-story or more condos has to account for the following items: roof, load-bearing walls or other primary structural members, floor, foundation, fireproofing and fire protection system, plumbing, electrical systems, waterproofing and exterior painting, windows, and any other item with a deferred maintenance cost in excess of $10,000 that may negatively affect any of those above items. So they have carved out a specific number of components that will have to be inspected now. This is a mandatory reserve study, and all of these items must be fully funded in the board's budget starting with the year 2025, and the membership waiver vote is now off the table.
So if you're a new person moving into a condominium, you need to understand that you may very well be paying for improvements to a property that you may not even live there by the time those repairs are completed.
Very likely. So the second part, that's the Structural Integrity Reserve Study. That is a requirement that all 3-story condos get done by December 31st, 2024, regardless of the age of the condo. Now, why is the age of the condo relevant? Because the second half of the bill deals with the milestone inspections, which Byron will detail shortly. The milestone inspection is essentially a visual overview of the building and its structural components. We'll get into the details soon, but it is a detailed report that will be provided by the licensed engineer or architect, and this report is tied to the age of the building. For 30-year-old buildings or older, they must complete the milestone inspection by December 31, 2024, same time frame as the SIRS report. For those condos that are younger than 30 years old, they will need to complete the report by the time they turn 30 years old based on the certificate of occupancy issued for that building. One caveat to that is, if your condo is located within 3 miles of the coastline, which is confusingly defined in the legislation, you will have to complete your milestone inspection within 25 years of the issuance of that certificate of occupancy. So we're going to be on disparate time frame, and it's going to be tied to the age of the building. So those will come in kind of a rolling basis.
Well, I mean, that seems so odd to me, but I guess that's the idea that when your building is that much closer to water, then you're going to expect a greater impact associated with the water and everything else. And that's just confusing. But okay, somebody thought that was a good idea.
And before we turn it over to Byron to talk about the actual contents of the milestone inspection and what that really consists of, I'll just note that from a procedural standpoint, these reports that have to be generated by the associations are legal in nature. They become part of the association's official record. They have to be distributed to all members of the community. They have to be recorded with the local building department and the state. So there's not only the requirement to do the reports, but there will also be a requirement to keep these reports, to distribute the reports. The goal here being transparency, both for our owners and our future buyers, because sellers are now required to disclose both of these reports to their buyers.
And I mean, we could stop there and it is a very difficult thing, is it not, for someone to go into any particular condominium, whether there's 8 units or 80, and really get complete information regarding the state of affairs at the structure. I mean, because I know personally I bought a condominium and then I found out 3 months after that they'd had significant complaints associated with water intrusion, and that they needed a new roof, and they needed a lot of new stuff. And here I am getting this massive assessment. So there seems to be a fairness factor here. But isn't there also a practical issue where many of these condominiums, this is going to be a pretty dramatic impact, wouldn't it? I mean, because I assume a lot of these condominiums have elected to waive reserves and then just kind of try and beat the clock on a lot of these improvements.
Yeah, I agree, Ted. This is going to create a real sea change with most of our clients, or many of our clients, who historically have voted to waive their reserve funding throughout the years, some of them from literally the inception of the community. So I do think that there is mass panic right now in terms of the cost and the budgetary requirements that these reports are going to impose. It's a question that I'm getting regularly, both from boards and from property managers. And the reason I'm very glad that Byron is here today is that I have no way to reasonably tell my clients what to expect with respect to these reports. So I'm relying on the expertise of Byron and other engineers to help educate me and my boards as to what exactly to expect through this process, and happy to turn it over to Byron right now to discuss.
Thanks, Dan. And I have been following along, as you have, throughout this process and trying to understand what the legislative intent is, in addition to what the specific language of the statute is. And I think if we back up and look at what the overall intent is for a second, it may help us better answer some of the specific questions. I think the intent is, first of all, to make sure that we have condominium buildings that are 3 stories and over, and are aging, are safe for the occupants. That's number one currently. And then also that they're going to remain safe for the occupants by setting up a program of forced maintenance, or at least forced funding of that maintenance. When I look at the requirements of the milestone inspections, first of all, there's the phase 1 inspection, which is a visual inspection. I think that myself and any other engineer or architect that really has the desire to do these inspections correctly is going to not only start with doing a visual inspection, but also start with understanding some background history associated with the project. We've actually generated a questionnaire that we are sending out to potential condominium associations to fill out the questionnaire before we get started, so that we can get a better understanding of what we're getting into. Some of the things on that questionnaire, obviously, how old is the building, understanding where the location of the building is, understanding what the construction type is. Now, the association may not necessarily be able to tell us what type of construction it is, but we're also asking for building plans. And to the extent that those building plans may be available, we're saying, look, we'll get those plans from you. We will scan them in electronically. We will send you back a PDF so you have a permanent record of those. And if you use us for doing the milestone inspections, that's a deferred cost to you. So we're not even going to charge you for it. But from my perspective, doing any type of investigation on a building like this is understanding the design concept, understanding the type of construction. The easiest way to do that is a review of the construction documents. Also, a review of the construction documents may lead us to another one of the questions that we have. Are there known construction deficiencies or defects at the property? Was there a construction defect claim? Thinking about Ted in this regard too, are there any known insurance claims or insurance payments that have been made? Did you have a Hurricane Irma claim, or is there some record of previous sinkhole conditions of the property that have been remediated? Those are types of things that we're looking for to kind of build the background associated with it. Also important is, what is the maintenance history? right? Because, do we have a building which has been chronically underfunded for reserves and deferred maintenance has been going on throughout its life expectancy? Or do we have an association and a building in which they have been diligent about making sure they have proper funding and they're going through their routine maintenance, they're replacing the roof when it should have been replaced, that type of thing. So understanding the maintenance history, and then also understanding what the building use is. Dan and I were talking a little bit earlier today about the use of a building. If you have a 7-day rental building that is on Gulf Boulevard in Indian Rocks, I don't even know if Indian Rocks would allow a 7-day, but we'll go with it for this. If you have a 7-day rental building, you're obviously going to have a lot more traffic in that building than you would, say, a building that doesn't allow rentals. And so, yes, the use is going to become important as well. And, really what we're thinking about is go out, you do a visual inspection of the common areas of the building, you review the other documents and stuff that I've just mentioned to you. You perform an inspection on a number of the private units. Now, we don't know exactly what that number is because some of these other items that we've discussed is going to drive the decision on the number of units. I've heard some people say they're going to do 25%. Some people say they're going to do 50%. I'm saying that until we know what our construction type is and what our history is, then that's really going to drive the number of private units that we get into.
Yeah, and just as a practice pointer for all of the managers and board members, who are listening, this is why it's so critical to keep good maintenance records at the association. I mean, for any number of reasons, but what you just heard from a professional who is going to have to perform a very detailed and very costly inspection of your building, the more information you can load them up with, the easier it is for them to do your job, and you make your life easier. And I hear this all the time because, condos often change management companies every couple of years, and it's very convenient to say, well, the records were lost in the shuffle, or this management company didn't do a very good job, or whatnot. But it's incumbent on the boards to really ensure that they are undertaking best practices with respect to record keeping and particularly maintenance. And this is true for your kind of claims, Ted. I know because we've had this discussion before for inspections like this that Byron would perform. It is absolutely critical for you to maintain those maintenance records to the best of your ability.
Let me interrupt for just a second and be Captain Obvious. My reaction to a lot of this is that there is virtually no consistency that will come out of the variety of engineering firms that decide to get into this particular business. Is that fair? I mean, because by the way, does the statute require that the investigation be done by a particular specialist, engineer, contractor? What is the requirement for that?
Well, it has to be either an architect or an engineer that is qualified to perform such inspections. So, you and I have done this for a long time, Ted. You know that sometimes you would get a electrical engineer doing geotechnical work. That's not qualified. Sure.
Right.
So it needs to be an architect or an engineer that has the qualifications in the investigation of structural issues with buildings. In addition to being a professional engineer, I also have the qualification as a special inspector in the state of Florida, which is also known as a threshold inspector. Since the mid-'80s, Florida has what's considered to be threshold inspection laws, in which buildings similar to what we're talking about here today would have to be inspected during construction by a special inspector in addition to the city or the authority having jurisdiction. So I think that one of the questions that still remains to be answered with this is that our reading is that certainly phase 2 of the investigation, which we'll talk about in a second, would need to be done by a special inspector. My recommendation would be that a special inspector also do phase 1. And oh, by the way, to toot my horn a little bit more, I'm also a certified general contractor, so gives me a kind of a leg up on doing the reserve studies as well. So in the phase one inspection, at the end of the day, what we're looking for is what the statute has termed substantial structural deterioration. And I could get into the paragraph that defines that, but in essence, what we're looking for is signs of structural distress that may be negatively affecting the building's structural condition or integrity. They have changed it in the latest version of the statute versus earlier versions of the statute to say that that does not necessarily include surface imperfections, cracks, deterioration, sagging, etc., unless, in accordance with the opinion of the professional, those surface imperfections, cracks, distortions, sagging, etc., are evidence of substantial structural deterioration. If in the findings of the investigator or the engineer or architect doing the phase one investigation, they find evidence of substantial structural deterioration, then that is going to be reported and a phase two investigation is going to be undertaken. So before we move on to phase two, Dan, Ted, do you guys have any questions about what I've talked about with phase one?
I do. Then, all right, so there's going to be some kind of certified report with your seal on it. Phase one report, I did not find substantial structural deterioration, ergo, there is no need for a phase two milestone inspection, okay? When you provide that opinion, to whom are you making that representation?
To the authority having jurisdiction, to the building official,
okay.
The building official. And
to the building. Okay, got it.
Local building department, they're going to get a copy of these reports because they're supposed to be the tracking system for this and helping us with implementation. A copy is also going to go to the board. So the board is going to get a full copy of the report, the full detailed copy, but then also a summary report. And that summary report will, by law, have to be distributed to all members of the association. It becomes part of the association's record for 15 years. So there is a transparency component here that everyone in the building, including tenants, will have a right to know what the condition of the building is.
I guess my question, though, is what if you're wrong and a unit owner comes in and buys a property in reliance upon that report, and they want to start a fight with either the association or with you over whether there really was a need for a phase two inspection?
Well, I think that gets back to the professional liability of the engineer or the firm that's doing that report. And that was my question really to Byron is what is his sense, if any, at this juncture as to how likely engineers are to give a healthy sign-off on the phase one inspection. And the reason why I asked that question is kind of twofold. Number one, by statute, that certification is good for 10 years. So theoretically, that association does not have to look at that building again for a 10-year period, out of sight, out of mind. And number two, what we're all kind of wondering is whether or not the engineer will be, worried about the professional liability associated with giving a sign-off based on just this phase one inspection. And Byron and I talked about this earlier, and I think a lot of it will have to do with the type of building it is and how likely it is that there are things that are not going to be readily apparent to the naked eye. And I think we're all thinking the worst case scenario here, which is that if I'm an engineer and I'm worried about a potential claim because I mess up on the phase one inspection and it turns out there's a substantial defect that I missed, because phase two, which Byron will get into, that involves more invasive or destructive testing to really get to the heart of what's going on at the building. So Byron, thoughts on the likelihood that the phase one inspection will actually come out healthy?
Well, I think it's going to go back to the discussion that we had earlier, and you said it yourself, is that it starts, in my mind at least, with what is the type of construction. And then we look at those other questions that we had. What's the type of construction? What is the age of the construction? What is the maintenance history of the structure? There's certainly scenarios where I could see that you have a good construction type. Let's say it's all cast-in-place concrete, load-bearing walls down to pile foundations, no two-way slabs, all one-way slabs. and it's been maintained well, and it's in Winter Park. I could see it. I could see that very easily passing a phase 1 inspection. The other scenario is we could have a building which is wood frame covered in stucco that is, built on the intercoastal, and I could see that never passing a phase 1 inspection.
Is there a sense that people could shop engineers for a particular engineer who'd be more willing to overlook the condition of the property? I've seen.
I think you're the best person to answer that, Ted.
I guess so. I guess I just, from my experience with dealing with condominiums, sometimes is they'll say, "Oh, there's this giant crack running up the side of the wall." That's bad, and they'll go, "I got a guy that says it's fine. Just stucco, restucco, or paint, patch and paint. We're good."
Well, but isn't that association now opening themselves up for liability?
Yeah.
That just seems like a recipe for the association getting themselves in some hot water. Dan?
Absolutely. But I think that most people are taking this seriously. I think that most associations are going to comply with the spirit of the law, and they are going to try to do the right thing. But I think we're foolish to think that there are not some condominiums that, for cost-saving purposes, are going to engineer shop and try to find the person that, basically tells them, wink, wink, nod, nod. Yeah, no problem. I'm going to give you a healthy phase 1 inspection and, carry on with your lives, when a responsible engineer would probably have a different opinion. And there's nothing we can really do to prevent that. That comes back to the board's fiduciary duty to the corporation to act in good faith and to act in the best interest of the community and its members, and for that engineer's professional and ethical responsibilities to provide accurate and adequate service to their clients. So I think that will be an issue, unfortunately, but I by and large think that most people are taking this very seriously, and their membership will not stand for them shirking their responsibility here and not really taking the best interest of the community to heart.
And I think that we were talking about this briefly beforehand, is that I think it's important for whoever the engineer and contractor that's putting together these investigations and then the reserve studies, I think it's imperative of them to try to get it as accurately as possible, because I could see the scenarios on each side of the equation where, let's say the reserve study is done very conservatively, too conservatively, and now you're collecting more reserves than what is necessary. Well, what does that mean? It means that your monthly dues are going to be artificially high. There may be a special assessment that has to take place. There may be funding, a loan that has to take place. And so what that means is it's going to negatively impact the resale value of those units. So, that's a problem. The other side of the equation is that the reserve study is too low, and there's not enough money being put aside to make these major renovations. And then 5, 10, 15 years from now, there has to be a special assessment, or there has to be financial arrangements made so that these major renovations that we're known about can be done.
Yeah, and Ted, there's a couple of interesting, purposeful ambiguities, I think, in the statute that may help illuminate some of this stuff by the end of the year. And one of which is that the statute says that the Florida Building Commission will provide recommendations to the legislature to adopt more comprehensive standards for maintaining and inspecting these buildings by the end of 2022, which is nice, if it's done on time, if it's productive, and if they can provide some kind of clarity. I think that will help Byron and the engineers and the architects better facilitate these inspections and know how to tailor their reports. The statute, does have some language about what that report on the phase 1 milestone inspection must contain, and it's detailed enough, I think, to conclude that the purpose of that inspection is really to obviously assess the overall health of the building and also to create essentially a maintenance plan for that building and an estimated cost of repair, for the building. It's, part of the contents of the report have to be obviously whether there are any unsafe and dangerous conditions and recommending any remedial or preventative repair for any of the items that are damaged but not substantially structurally deteriorating. So to me, and Byron's already on this and we were talking about it earlier, it's essentially a report that is going to wrap up in a nice bow your maintenance protocols on the building. If you get a good engineer to do it and provide a comprehensive report, then what the board should be able to do with that report is say, here's how we build out the preventative maintenance protocols for this building in order to, preserve the integrity of the building, obviously, to lower our overall maintenance costs if possible, and to ensure the maximum useful life of these components. So there's a lot of value added to the associations for this report, but I think this is why the association should be prepared for the price tag on these projects. It is a comprehensive report. It's a detailed report. It's an important report. It has a lot of value to the community if used correctly. And if you hire the right individual or the right firm to do this, it's some temporary pain for a lot of long-term relief. And I hope that my clients and all the condos throughout the state will try to look at it in that positive light as this is a good thing. This is essentially the legislature reconciling decades and decades of a hands-off philosophy. They've just allowed these condos, short of a board breaching its fiduciary duty and literally not maintaining the building, they just have left condos to their own devices and said, fend for yourself, good luck. I hope you have a good board. I hope you have a good management team. I hope you hire the right professionals. We hope you do the right thing. And, there's zero oversight. So now there's oversight.
Right. Well, and I think that nobody ever really wants to have their home inspected by an engineer with the prospect that the engineer is going to come back and tell them that, oh, by the way, you don't know this, but you have a defect in your foundation and now it's going to cost you, $25,000 to resolve that. But we all know the sooner we get to these issues, ordinarily, the better we have a chance at mitigating the effects. It's just, I do think that this issue associated with the reserves, I hear with so many of these condominiums that the cost of their insurance has gone up, 2 and 3 times what they had been paying 5 years ago. And now all of a sudden they got an additional premium burden, but now they also are going to have to say, how old is our roof? Well, I guess if it's got 7 more years, we're going to have to figure out how to divide the cost by 7 and divide it by all of the unit owners. A lot of people that live in condominiums may believe that by living in an environment like that, that they may have fewer expenses, but it's going to get costly for some of the condominiums that I've dealt with. I mean, at the condominium that I lived in for a while, we had a place down on Treasure Island. The amount of water that was coming into that unit, I think would easily place this in a state of deterioration that would have required them to do a phase 2 study. I'm certain of that. But then, of course, we get into the condominium and then we find out that there are all these issues. And now here comes this massive assessment. And that's when I had to sue my own association because of the issues that they knew about but failed to disclose to me when I bought my unit.
Yeah, and on that note too, this is maybe a little strategy pointer here for anyone who's listening and wants to try to use their dollars as wisely as possible. And so one advantage to doing this study, obviously, is that maybe for the first time in the building's history, someone of competent nature is going to be doing a neutral third-party review of the building and its structural integrity and all of these components. And the reason that's important is because of potential construction defect issues. a lot of us think of construction, at least in my world, right? A lot of us think of construction defect issues as related to the developer, stuff that, after a community turns over from the developer to ownership control, there's this period of time within which the owner-controlled association has to evaluate their buildings and bring claims against a developer for actual construction defects. And there's statutory timeframes that have to be met. The outset is a 10-year period from construction of that building. But construction defect claim may arise outside of the 10-year window from original construction and may have nothing to do with a developer. So, I'm thinking of the hypothetical of a 20-year-old building that maybe has, done their first roofing project a few years ago. So they've done $1 million or a couple $1 million worth of roofs on several of these 3-story and higher buildings. They haven't experienced a problem yet. The roof is, a few years old. That building, by law, may not be required to do a milestone inspection for another 10 years if they're 20 years old. However, if we waited all 10 years until the 30th year and did our milestone inspection, we would be outside of the 10-year ultimate statute of limitations to bring a claim against that roofer who did the reconstruction project, the roofing project. So in doing these inspections within the statutory time frame from a major reconstruction project on your building, you're actually going to capture potentially a claim for any defective work against that vendor who performed services on your building. So, I guess I'm suggesting that there are certain benefits that are kind of sunk into this, that if we have a good strategic discussion among the board and its attorney and its property manager, that we can come up with the most effective way and the most effective timing to do these projects to extract maximum value and protection for the association. But that's really going to take the boards and the managers being educated enough to know that there are multiple strings attached to this, that they really need to consult with their general counsel attorney or a specific construction defect attorney to evaluate what potentially they can be doing to help themselves in addition to just satisfying the statute.
When are we expecting these inspections to begin taking place? Pretty much now?
Yes. We're actively talking to some associations about providing them with proposals to do these inspections. I would say that if the proposals come through, we would start immediately on performing these. I mean, so specifically on the phase 1 inspections, I really don't see any reason to wait on it because once again, you may get a clean bill of health from phase 1.
Well, and if you're a 30-year-old building, I mean, you have to get it done by the end of 2024. And I think implicit in your question is the concept of supply and demand. I mean, I'm already hearing now, that there's not enough engineers and architects in the state to visually inspect every 3-story building or higher.
I'm telling you that is false, Dan.
Okay.
There's plenty of us.
Thank you.
We need nobody else coming in.
Stay away.
That's a whole other topic, which I 100% agree with Byron. But okay, so point being though is the lines are going to start forming now. And if you want a good firm to take care of you, then they're going to be the first ones to book up. That I can guarantee.
Yeah, and to that end, Dan, one of the questions that I think is coming that I haven't heard yet is how long is this process going to take, right? And it's really going to be incumbent upon, once again, things you were talking about earlier, things I was talking about. How well kept are the maintenance records? How easily can we review them and see what's going on? Once again, I think that the phase 1 inspection just starts with a general walk around the building, walk around the property. You get a good sense of what's going on, and then you kind of tailor what additional areas you may need to get into. If a building doesn't have a lot of issues, we have good maintenance, we have building plans, I think the phase 1 inspection the inspection itself could take place within 3 to 4 weeks, given our current schedule, and then it would take another 3 to 4 weeks to finalize the report, because our report is going to be detailed enough to understand, all the different things that we've done. What is the construction type? Who put together the plans? It's going to be detailed, and it's also going to make recommendations. Now that is the phase one report. The reserve study would take longer simply because I think that you have to, at a minimum, have the background of the phase one in order to do the reserve study. And then the reserve study, you're going to have measurements of the building, either from plans or from the field, or from satellite imagery, depending on what we're talking about. You're going to have an understanding of what the life expectancy of the individual components are. The reserve study is going to take a little bit more time just because there's more going into it.
Is there a way to do the reserve study without doing what essentially is a milestone inspection?
Not in my opinion.
Okay. So this presents a problem, Ted, because like I said, we have two disparate timing elements for the reserve study and the milestone inspection. And this is, for the 30-year-old buildings or more, they're on the same schedule. But the 20-year-old building that has to have a reserve study done by the end of 2024, but doesn't have to have a milestone inspection done until 2032. How do you reconcile those two things, Byron? And are you going to suggest to them to just marry those two together because it's going to be more efficient?
Well, at the end of the day, whether you call it a milestone inspection or not, in order to do the structural integrity reserve study, you're going to have to go through the same steps as the milestone inspection, and then some. So my recommendation would be, yes, just go ahead and do your milestone inspection and your reserve study because you're going to need it anyway and get it over with. And then one of the things you're doing is you're making, when the next 10 years comes around, this process is going to be a whole lot easier and a whole lot cheaper.
But so the contrast to that, of course, is that if you do the milestone inspection now, you've created an additional reporting cycle for yourself because you theoretically don't have to do it for another 10 years if you're a 20-year-old building. So you do one now, and that triggers the 10-year recertification requirement. So you've built in additional cost to the association, which could be a tough sell. But on the other hand, if you're telling them that the reserve study is going to really entail a lot of the same things, if not all of the same things or most of the same things as the milestone inspection, then why not kill two birds with one stone? It's going to be a very difficult conversation to have. And one of the suggestions I saw recently from one of the very good condo attorneys in the state and something that's being presented to the legislature for consideration is tie the reserve study to the milestone inspection date, and I don't know whether that's a good thing or a bad thing. And I would put that question to you. If I'm a 20-year-old building, is there, aside from financial planning, because the reserve study obviously helps us with financial planning, is there any benefit to doing a reserve study by the end of 2024 when our milestone inspection date is not due for another 10 years? Or how would we suffer if we put off the reserve study for another 10 years to sync up with our milestone if the legislature were to amend the law and allow for that to alleviate some of the burden on the professionals in trying to get every single 3-story condo reserve study by the end of 2024, which I do think is going to be a mad dash. What would be the downside to extending the reserve study component to match up with the milestone date?
Well, I think that it goes back to the same things that we were talking about earlier. I think that in some instances, extending it would not be a big deal at all because you have a building construction type, you have a location, you have a maintenance program that are all favorable. Contrary to that, if you have a building construction type, a maintenance schedule, and a location that is not favorable, then I think that moving the milestones sooner would be more beneficial.
Yeah, this is really
Let me see
interesting.
if I can try to kind of wrap things up a little bit and a couple of packages here. So the first thing is, if you're on a board of directors of an association, you need to be talking first to Dan Greenberg or someone who is your condo or lawyer to understand what the status of your particular community in the context of this new law. Meaning that how old is the building, how many buildings are there, how tall they are. Those are the kinds of things that are going to affect that. Then we have this issue of needing both a reserve study and a milestone inspection. Byron, you're saying Byron Anderson of 𝗖cie. Before we get off, I'll have both you guys give your websites. you guys are starting, Byron and your crew are starting to formulate what these inspections are going to look like and the steps that are going to be involved. Now there's this other part though on the reserve study. Dan, if I'm on a condominium association and I need a reserve study, there are vendors that actually perform those tasks, aren't there?
Well, there are vendors that perform those tasks, but there are not vendors that perform structural integrity reserve studies as detailed in the statute. Those must be done in conjunction with a professional engineer or architect or special inspector or CGC, such as myself, that can determine what the structural impacts of any degradation is and what the life expectancy and what the recommended repairs to those items would be. So no, to answer your question, your run-of-the-mill company that was performing reserve studies does not have the qualifications, in my understanding at least, to be able to do the structural integrity reserve study.
I guess because all they would be doing is they come in and say, your roof is 12 years old. The roof, when you bought it, had a warranty of 20 years. So you have 8 more years usable life. In our opinion, a reserve to fund that would be this amount, and it would be divided by this number of people who live in this community. But here we're talking about the reserve study ends up being derivative of the inspection that's done by the engineer.
That's correct, because the statute requires that the visual inspection portion of the reserve study must be done by a licensed engineer or architect. And to Byron's point, there are just far more components to the structural integrity reserve study than the traditional reserve study that has historically been performed by, those reserve study specialists. So, I think they may be partnering with firms like Byron's is what's going to happen, so that they may be very adept at building out the financial component of the study, because that's what they do on a day-to-day basis, but they are not going to be adept at actually inspecting the structural components of the building above and beyond what they're accustomed to doing, and they are going to rely on engineers like Byron to assist them with that in order to provide those studies to their existing clients.
You're correct. We actually are supposed to be having a call right now with a contractor that does reserve studies, talking about teaming up with them. So yes, absolutely. Before we get out, Ted, there's one component of this, the phase 2 inspection, that we did not discuss yet. If the investigating engineer or architect determines in phase 1 that there is substantial structural deterioration, then a phase 2 investigation has to be undertaken. Dan and I were talking earlier today. The phase 2 could really go one of several different ways. You could have substantial structural deterioration on a localized area of a building. Let's say you're doing your investigation and you found a column in the garage that was hit by a truck, and that constitutes substantial structural deterioration from the truck impact and the corrosion that occurred after that. But really, that would be kind of a localized problem, and your phase 2 investigation may not be all that intensive, and the costs associated with repairs from the phase 2 may not be all that expensive. On the other side of that, you may have a 50-year-old building that's on Gulf Boulevard that's never had a major renovation done to it, and the phase 2 investigation may incorporate extensive intrusive or destructive testing, repair drawings and repair recommendations, and the cost associated with that could be quite expensive, and then the associated repairs that were necessitated by the phase 2 investigation could be quite extensive. Once we've completed the phase 2 investigation, we are determining what deficiencies have been identified. We're quantifying those deficiencies. We're providing repair recommendations and basically setting it up for a traditional building renovation type project. And then that is also submitted to the authority having jurisdiction. And Dan, correct me if I'm wrong, I think there's a time limit that the association has before they can start remediation.
Well, they have to start remediation within 1 year of issuance of that report that indicates that there is a need for repair to the building. So there's a 1 year time frame, and this will all be overseen by the local building departments. And Ted, I do want to add two things before we go. Just one thing, because I get a lot of questions on the reserves. So obviously this sets up now 9 brand new, well, some existing, like your roof and other components that we were accustomed to accounting for. But this will set up 9 distinct component reserves that have to be fully funded, through the structural integrity reserve study. But for all the other reserves that the condo currently has, whether that's for your pool pump and irrigation system outside and all these other various things, you can still continue to pool those reserves, which is a very valuable tool that condos use so that they don't necessarily have to fully fund, but have all their reserve monies available for replacement of those items that are in the pooled reserve account. That all can continue for all items other than the enumerated items that are part of the structural integrity reserve study. So you're going to end up having like a hybrid reserve model basically come 2025 after we've done all these reserve studies. So that was one question I get a lot is, so some of the reserves are going to stay the same. Some of it is going to change. The other thing is too, kind of back to the construction defect discussion, which I just think, unfortunately, boards are going to have to be thinking about. It's not a pleasant concept, but it's just something we have to deal with. Developers are now required by this statute to provide milestone inspections and structural integrity reserve studies prior to turnover. So they have to comply with this statute as well. So if you are a newly constructed community and you are pre-turnover, you can now expect to have these reports generated by the developer and their chosen engineers. So my best advice to you, if you are approaching turnover or you are newly turned over, is not to necessarily rely on those reports generated by the developer and their chosen engineers, just like they are required today and prior to this law to provide audits and inspection reports to you. You need to have those reports reviewed by an independent engineer, whether it's Byron or your other professional of choice. And I'm not, saying that every developer is acting inappropriately or that they themselves are shopping for the engineer that will tell them what they want to hear. But we just simply cannot take as truth everything that is presented to us, from the developer at turnover. So I am still going to advise my clients post turnover, to have their construction defect team take a look at those reports that are provided, dig into those with a little bit of detail and not necessarily take for granted that clean bill of health is something that you can absolutely rely on. This is just the world that we live in, and I've seen too many construction defect cases and turnover cases to conclude that we can reasonably rely on every single thing that's provided to us from the developer. So it's nice that they have to provide those to us, and it may give us a working basis, to then go from, but I think we need a second layer of review.
Well, if I can make one overall observation, I strongly advise all individuals that are involved in living in condominiums or on boards of directors that they seek competent counsel. And I know we've heard a lot of really great advice today from people who are going to be involved in getting these things figured out. So again, I want to say a thank you to Dan Greenberg, who's a condominium lawyer who I turn to when I have questions about condominium law. And I appreciate you coming in today, Dan. And Dan, I know you have just changed the name of your firm. What is your current website that you're working from?
Yes. So my firm is Greenberg @. Our website is www.associationlawfl, like Florida, .com, and you can email me at dan@associationlawfl.com if you have any questions. And again, thanks, Ted, for having me on. I think this is a very important topic. This is going to be of tremendous value to everyone listening. And this is not the first or last discussion that we are going to have on this topic. So expect to hear from us again. And we're happy to provide information because we're all going to be dealing with this for the next several years.
Yeah. And I want to take a minute to thank Byron Anderson for coming in. Professional Engineer et al. Lots of other things as well. Byron, go ahead and give us the identity of your website so
Sure.
folks can reach out to you if they have questions or if they are ready to move forward on these kinds of things. Go ahead.
It's the company is Structural Engineering and Inspections Incorporated, which is typically called SEI. That's Sam Elizabeth Indigo. And our website is www.seiflorida, spelled out. That's SEIFLORIDA.com. And information can be sent to, or questions can be sent to info@seiflorida.com.
Fantastic. Gentlemen, thank you for coming in. Again, this is Ted Corless with the Corless Law Group. You all be well out there.